Please be seated. Good morning. We're here for oral arguments in cause number CV170728, Donald et al. Versus Papadakis et al. These proceedings are being video and audio recorded, so we ask counsel to please identify yourself and your client at the beginning of your argument. Each side will have 20 minutes. Appellant's counsel is responsible for watching the clock to reserve a portion of that time for rebuttal if desired. Also, we've read the briefs, we've discussed in this case in conference, and at this point we're very familiar with your arguments. If you'd like to proceed.
Excuse me. Thank you. Good morning. May it please the court, my name is Frank Murray, and I represent appellants, plaintiffs in this matter. I am going to try to reserve time, but I'm fully aware of how that sometimes turns out. So I buy in on all counts with respect to that. We are appealing and have set forth, I think, some clear grounds with respect to appeal. What I want to talk about, I suppose, is sort of analogous, and this is appellate court language, I guess, come to think of it, to an emanation and a penumbra that sort of flies out of the briefings of my opponents on this matter. And that is that we somehow didn't desire arbitration, or that we sought to pursue this case in Maricopa County against the parties to which we were obligated to go to Florida and arbitrate against. And that's absolutely untrue. I want to lay that to rest with facts that you may have noticed. We initiated this action, I think, on February 12th with a complaint. We had called AAA first and said, excuse me, can we file the same complaint to initiate the AAA action that we do the Superior Court action? Will you accept that? Because it seemed that the AAA rules did so. They said yes, and so we did that, and we drove up to their offices at a building we used to call the Esplanade up on Camelback, and we filed that in our $7,000 check, and we initiated this action in front of the AAA in that fashion in Florida. First thing we did. What we did the next day was to file the action in Superior Court on the 13th. And so I want to...
If I could cut to the chase here a little bit. You don't deny that in the original agreement there was an arbitration clause.
Sorry.
We're going to take it a step at a time.
Absolutely not.
And that there was a requirement that any court action would be filed in Florida.
I don't know about the exact verbiage of court action. We have defendants here
Doesn't it say that it would be filed?
Who are
not. It was
Hillsborough.
I always get that confused.
Hillsborough County is, yeah, that's
and
Tampa.
Florida.
And we were required to do that and did that in front of the AAA in Florida with no intention of submarining the AAA action. In fact, the intention was to facilitate it.
And knowing that there's a mandatory arbitration clause, what was the purpose of filing a complaint in Superior Court and then in the Superior Court in the wrong state?
Well, the Engs were in that complaint.
Well, you didn't need to name Papadakis in that complaint.
Well,
did you?
we did use the same document that was furnished to AAA to initiate the lawsuit in this case, and it included Holden, Papadakis, and it included the USL, absolutely, who were parties to be arbitrated with, which we had already initiated in Florida. We also brought that action here at the same time because the defaults that were claimed in that instigated this action, that caused the defaulting of the franchise agreement that set it off, concerned lots of local witnesses and local parties who we thought we might have to move to depose or to regulate discovery with here in this jurisdiction, and it might be good to have a companion court. Since the two matters had a joint defense agreement in them, that might be facilitated by having a court here that would administer the process, if necessary, only if necessary. We didn't do.
But you didn't need to have that complaint filed in order to do that against these defendants.
As it turns out, that did not come to pass. We did not utilize that provision here. My opponents point out that there is no such thing as an inactive calendar anymore, which is what we were intending to do. There is, although it's called something different these days, something called the dismissal calendar, which permits a case to ride and has 5 different characteristics that it looks for in terms of administering that matter in Maricopa County. And the third such matter is arbitration. So there is a provision for this. There could have
arbitration in another forum.
It doesn't specify which forum. It just says arbitration. But cases that become interrupted by a referral to arbitration, or cases that get interrupted by bankruptcy petition.
But here it provided that any litigation was going to be in Florida, did it not? Against these parties.
It did, and it was.
I guess I'm still just trying to understand why it would make sense why it was necessary in some way to name them. You're suggesting that there was no other mechanism to be able to take depositions here or something?
As it turned out, we did not have to rely.
Even as it turned out, are you saying there was no other mechanism to be able to take depositions? It still seems like an odd thing to have to necessarily name them in a lawsuit where you've agreed that the proper forum is a different state.
Enforcing disclosure that might arise against the non-arbitrating party that could matriculate into Superior Court, that through the joint discovery agreement could also implicate AAA.
Joint discovery agreement
between
Mr. Eng or in?
Between the two actions, between Mr. Eng and between the USL and between Holt and Papadakis and between us. The two cases were joined with a joint discovery agreement.
I'm a bit confused, and you have two parties and you sue them both in Arizona. With one party, you have a very distinct, very clear arbitration requirement and choice of law requirement. With one party, you don't. Why would you include them in that suit if you knew it ran afoul of your contractual obligations? That's what I'm not seeing. You could have just sued the one party in Arizona and been perfectly within your limits, is what you're telling me. Am I understanding this correctly?
We could have been within our limits. It might not have been the most effective way to administer the case. We could have tried to apply later to have a local court under the joint discovery agreement enforce a deposition or rule on questions or evidentiary issues with respect to discovery. I suppose we could have done that later, but that's why we filed the matter.
So if we back this out of your case and we talk about any other case where you have two parties that possibly have liability and an arbitration requirement between the plaintiff and the other party, you say in all cases we should file a case in a forum that is not designated in this case with this party. That's what I'm not understanding. And I don't think the rules of civil procedure contemplate that.
I think something that makes a big difference in this case is that joint discovery agreement that the parties agreed to that could produce situations where local judges here are ruling with respect to local witnesses, local matters, local written discovery.
Couldn't they do that if the lawsuit had only named Mr. Eng and the court issues an order in that case where he's the only named defendant? Why, if the parties have agreed, why would they not be bound by or comply with the directive made in the, if we were to call it the Eng case?
I think with the limitations in mind of arbitrators and their ability to enforce discovery early in a case, and with respect to the clear ability of a judge to order such an enforcing order with respect to the local defendants in this
Hey,
case.
you lost me because you just said that the arbitrator's ability, but we're talking about Judge Catani's question was, why couldn't you have just gotten that discovery in the Eng case? And the court clearly would have had, if there was a discovery dispute in the Eng case, could have ordered discovery, correct?
Yes, certainly the court could have ordered discovery there, but Eng's role with respect to these offenses and even some of the counts in the case differ between Mr. Eng and the USL and Mr. Holt and Mr. Papadakis.
But for those, you had an arbitration agreement that needed to be heard in Florida, right?
Yes.
So there may have been different discovery, but that was under the authority of the arbitrator in the Florida case, right?
Yes.
Okay.
And because of distance, lack of proximity, and inconvenience, it could have been very cumbersome.
If we pause for a moment and take this out of the context of your case, arbitration and AAA provisions are put in contracts to make sure that we don't end up in protracted litigation in our court system. That's what it was adopted for, in my understanding. So in this case, what I believe you're doing, and I'm not sure if I'm wanting to make sure that I'm not ascribing any false, ambition to why you did what you did. But what it seems to me is, instead of keeping the arbitration what it is, which is a fast track to the conclusion of litigation, which is why it's included in contracts, you ask the Superior Court to assist the arbitrator, which just seems counter to the whole purpose of arbitration.
And then we proceeded solely in front of the arbitrator with respect to all of those issues as the case went forward. And the principal reason, Your Honor, why that happened was that we had lots of local issues that were asserted as defaults that would have involved local witnesses that, as time went on in the case, were withdrawn as defaults by the other side, who wound up finally proceeding to the final arbitration, seizing on a default with respect to one payment under the contract, and not whether or not we had a stadium at the Peoria Sports Complex and whether we had workman's comp for all of the players and all of the ticket matrix and whether we had an advertising presence in the community, all those other things that they asserted as defaults, which would have involved us with local witnesses and would have involved us conceivably in issues that poured over to Mr. Eng.
What relief do you want on those? Are you want us to order this case back to the Superior Court to just sit there? I mean, is that what the relief you're asking for?
The relief I'm asking for is that the order cannot possibly be final. An order that has with prejudice language and 54B language in it, with respect to a proceeding in which the judge heard no evidence, accepted no documents, listened to nothing on the merits, cannot possibly result in this case. And the case is still alive.
So you want us to remand it back so it can just sit there? That's what you're asking for?
Remand it back so the language can be changed so that the order itself that was issued, which was incorrect, doesn't rise up and plague proceedings.
If we just
further.
order that the dismissal be without prejudice, does that solve your...
That's what I'm seeking.
And you're good with that?
I'm good with that, and I have a few fee complaints.
So are we really here over the fee complaints? I mean, is that really what we're here for?
No, I felt, Your Honor, and this is just, I can only say this, I guess, as a practitioner. When I saw the language from that judgment, I couldn't let that stand. That it's with prejudice, that it is final and there's no just cause for delay, and it should be entered and certified as Rule 54B. It wasn't, it can't, it shouldn't. And
if it's dismissed without prejudice, I mean, it's dismissed, it's gone. It's not writing the calendar as you've requested. I mean, it's just gone.
Your Honor, my writing the calendar discussion was meant to tell you initially why we did that. And then I tried to give you a flavor a few minutes later for how the defaults all changed, and we didn't have 20 witnesses in Arizona like we did at the beginning that would have had to have been administered here.
Still hung up on that point. So you think it's appropriate, if you're engaged in litigation in a different forum, to file a companion lawsuit in the jurisdiction in which you think the witnesses will be found?
Your Honor, I think it's appropriate to let a lawsuit ride in some respect locally when it's removed for arbitration, and I don't see the difference here. And I've often been involved in cases that did just that.
Let's say Mr. Eng is not involved in any way. It's just that there are a host of witnesses who are in Arizona. Would that have been a basis to file something here when there's an arbitration clause that says everything has to happen in Florida?
If we had decided, to jointly administer discovery under an agreement, then yes, that well could have been.
Jointly administered discovery I'm saying there's no party who has to be sued in Arizona. It's just that a number of things happened in Arizona and there are going to be witnesses in Arizona. Would you file a lawsuit in Arizona rather than just in Florida?
Under circumstances without Mr. Eng and without a joint defense agreement, I don't think I would have done it, no. Can I reserve?
You may.
Thank you.
Good morning, Your Honor. I'm Rodney Ott from the firm Quarles and Brady, representing the USL defendants who are appellees in this case. By way of introduction, one issue that hasn't been touched on yet is the obvious fact that the arbitration has been now completed. And we filed a request for judicial notice related to that arbitration award. With the arbitration,
Do we need to consider that to rule on these motions?
no, I don't think you need to.
I mean, it may be an interesting fact, but
It's an interesting fact, and what I want to point out is plaintiff's conclusion in both of their briefs. This is on page 20 in their opening brief. They ask for two things.
I'm going to have you move over and step up to that microphone so
Okay.
we can hear you.
Okay,
Thank
sorry.
you.
In their conclusion, they ask, for the reasons set forth above, this court should reverse the trial court's incorporation of Rule 54B language in its judgment and make any dismissal of this action at this early stage without prejudice, so that the court's greater purpose to safeguard the arbitration can be achieved. That's the first sentence of their conclusion.
And
That is now totally moot.
But what's wrong with that in terms of why should the dismissal have been with prejudice?
The dismissal should have been with prejudice because there was nothing left to do in Arizona. The court essentially looked at the complaint, looked at the contract, said, plaintiffs, we don't understand why you're filing here. You breached the franchise agreement. You breached the provisions on the arbitration clause and the forum selection clause. I've ruled on the merits. You're out of here. Your case should not be.
How are you ruling on the merits, though, of the underlying claims? Aren't you just saying you're in the wrong forum? Why wouldn't that just be a dismissal without prejudice?
Well, they are saying you are in the wrong forum, and that's a breach of the contract. But second of all,
But are they
there's
breaching any other issue on the merits other than you're in the wrong forum?
Well, I would think those are part of the merits, Your Honor.
I thought we said in Duenas versus Life Centers that a dismissal of claims subject to arbitration should be made without prejudice.
Well, I think that's
I mean, I can quote the language for you if you want.
if the case is coming back to Arizona for any reason, okay, that might make sense. But this case was not coming back to Arizona for any reason.
Well, how was your client harmed by a dismissal without prejudice?
Well, first of all, if I think what plaintiffs wanted was that the case would just hang around. That would be prejudicial.
Yeah,
and
but we've
that-
agreed that's out. But just a dismissal without prejudice, what would be the problem with that?
Well, Your Honors, we actually believed that if we got Rule 54B language, that would resolve this issue. It would allow the plaintiffs to appeal the issue of whether it was proper to dismiss the case based on the arbitration clause and the forum selection clause. We actually thought, let's resolve this issue and be done with it. And that's why we asked for Rule 54B language. And you can't get Rule 54B language unless the case is dismissed with prejudice. I mean, there is case law, I believe it's cited in here, to the effect that in order to have a final case, a claim, final decision on a claim that can be dismissed or with Rule 54B language, it has to be a dismissal with prejudice. And that makes sense here, because there's no reason for this case to come back to Arizona.
But does it make sense in terms of if there's some preclusive effect, if there are merits issues, are you saying that those have now been resolved affirmatively against the plaintiff through this dismissal with prejudice, and this means they can't be raised anywhere because they were addressed on the merits and rejected? Your case has been dismissed with prejudice.
Well, I think if you look at the judgment that the trial court signed, the trial court specifically says, I'm dismissing this case based on the arbitration clause and the forum selection clause. Those issues have been decided finally. Plaintiff can't raise them again in Florida or some other
But
forum.
those aren't the only issues in the complaint.
No, they're not the only issues, but they're the significant controlling issues insofar as plaintiff wants to sue the USL defendants in Arizona. And frankly, we were as confused as the panel seems to be about why they would bother to sue the USL defendants here. We asked the court to make a ruling on that, and the court did. And that particular issue, whether they can sue the USL defendants here in Arizona when there's an arbitration clause and a forum selection clause both saying Florida, that issue has been resolved on the merits in a final way. And that's what we asked for in the judgment with Rule 54B language. And now that the arbitration has proceeded and the arbitration panel has also dismissed plaintiff's claims, this whole issue is moot. I mean, if you were to reverse, all that would happen was you'd remand to the trial court to enter another judgment saying that, the case is still dismissed. All the claims are gone. Plaintiffs can't come back to Arizona on this. So to some extent, plaintiffs seem to be asking you to engage in some kind of futile wheel spinning.
Why can't we just affirm that and just modify and say it was without prejudice under our case law?
Well, if you said the dismissal was without prejudice, it would raise questions about whether this court really has jurisdiction to hear plaintiff's appeal.
Well, I know it was a case after this case, but in Dunn versus Fast Med Urgent Care, that came out on June 19th of this year, we specifically said that we do have appellate jurisdiction when a case is dismissed without prejudice as it relates to forum issues.
Well, I mean, if Your Honor, I think that when I was preparing here, I was considering there is the statute on appeals, 12-2101A, paragraph 1, a final judgment entered in an action. I don't think you would have jurisdiction under that if the case was dismissed without prejudice.
All I can tell you is the quote from the Dunn case says, dismissal pursuant to a forum selection clause is an appealable order under ARS 122101A3.
That's the provision I was going to. Conceivably, there's an argument, and now we've got a case saying that plaintiffs could appeal conceivably that kind of a dismissal.
But it should be a dismissal without prejudice.
Yeah.
Under a forum selection.
And the arbitration clause.
Correct. So we modify that portion and say it was improperly dismissed with prejudice. It should have been without prejudice. But no one, I don't hear any arguments that the arbitration clause or the forum selection clause were invalid or not enforceable. So I'm not sure why we're here other than the
Your Honor,
fees.
I completely agree with you on that. I mean, again, when we asked for Rule 54B language, we were supposing that the plaintiffs would challenge the applicability of the forum selection clause and arbitration clause. And by having Rule 54B language, it gave them that opportunity. They didn't choose that. Instead, they explicitly say in their briefs they don't agree, they don't dispute that the forum selection clause.
But there was an order that arguably goes to the merits of every one of their claims. That's, I think, their argument. But let's switch over to the fees. I mean, this does seem like a lot of fees for simply arguing we're in the wrong forum. Why? What was the basis for awarding the amount of fees that were awarded?
The court reviews the fee award. First of all, whether the trial court may award fees under the statute or the franchise agreement review that de novo. The amount of fees and whether the court really should award fees are kind of discretionary issues that this court reviews for an abuse of discretion. And plaintiffs have made a number of arguments why they think the amount of fees was excessive. But you have to keep in mind, first of all, we had two actions, we had an arbitration proceeding and an Arizona trial court proceeding going at the same time. We did have to coordinate with Florida counsel because, after all, plaintiff, as they admit, filed exactly the same document with the same claims in both places.
But aren't fees would be awardable in the arbitration proceeding? Wouldn't that be something separate?
Well, we question whether a Florida arbitration panel would feel that it has the authority to award fees for what happened in Arizona. And so we put in our fee application in Arizona for actions and legal expenses incurred in Arizona. It did involve a lot of coordination with Florida counsel. It involved 9 months of litigation. We had to do research on every one of plaintiff's claims under both Arizona law and Florida law. We had to be prepared to argue all of those claims under both Florida law and Arizona law before the Arizona trial court. There were various other issues that were raised, including, the applicability.
Too early on to say that this is improperly in Arizona? Why would you have to research Arizona law on all of the claims if they're...
Well, we did make that argument, but out of an excess of caution, we wanted to be prepared for anything that might come up. I completely agree. The lead argument here is that this case shouldn't be in Arizona at all. But we had to prepare in case the court didn't agree with us. And the court did agree with us. So, plaintiff, they also raised some other issues about the amount of fees. There's talk about a notebook of cases, and they speculate what was in the notebook. They talk about the rates. In terms of the rates, the lead evidence here is that the client agreed to pay those rates, so they must be reasonable. That's a significant bit of evidence that the rates are reasonable.
What about the duplicative argument that there were duplicate entries? Any response to that?
Well, that again raises the issue of the arbitration award. Okay. And when we made our fee application, again, back in October of last year in Arizona, we prepared it, we submitted it, the court examined it, and ruled on it. Now, plaintiff, as I understand it, is arguing that months later, in July, an arbitration panel in Florida looked at a different fee application prepared by Florida counsel, and that there were duplicative entries. And frankly, I don't know what was in the Florida fee application. We weren't involved in the Florida case. But what this court has to consider is what the trial court ruled on back in October of 2017, not what some arbitration panel ruled in Florida 9 months later. Now, if plaintiffs were unhappy with that fee award in Florida by the arbitration panel, they needed to challenge that there. As I understand it, their argument now is that something that happened after entry of judgment in another state in an arbitration forum should affect your decision when you're reviewing what happened back in Maricopa Superior County Court in October of last year. And that's not how the appeal process works. Any other questions?
Anything?
Okay, thank you, Your Honor.
Thank you. Mr. Murray.
Let me just say that the USL has filed to confirm the arbitration award, which is not final, has to be confirmed in the U.S. District Court for the Middle District of Florida in the Tampa Division, which is exactly where we would have gone if we were going to appeal it. And this is an advocate sounding like an advocate, but this is one of the 20% of those cases in that district in arbitration that are going to get overturned because the panel made some very obvious and fundamental mistakes. If it gets introduced in that panel that there is an order dismissing these claims with prejudice that is final with no just reason for delay and should be entered immediately, in that federal court proceeding, it's going to continue to give us trouble. This case is not over, as Mr. Ott says. It is not finished. It's not finished until that award is confirmed. The notebook about which we heard so much during this 20 minutes of argument on the miscellaneous motions calendar with respect to this matter in front of Judge Bustamante, I know what's in the notebook because counsel told us that day at the argument. They were all the cases that he had copied and put in the notebook, and you know how much that cost in the fee petition. And every case except, I think there are like 61 of them, except for 2, are Arizona cases. They had nothing to do with the Florida law that controlled the issue that he was supposed to be there arguing. With respect to the overall fee application, we submit that it's actually ridiculous considering the amount of work, and there isn't an equivalency in the law between what you expend on an issue and the other side does. But I will tell you, for us, this was a $1,000 to $2,000 matter with what we regarded as a housekeeping motion to try to keep the case on something like an inactive calendar in Arizona for that purpose.
Is there any time that you explained to opposing counsel what your purpose was as you've explained it to us in filing that? And did you do that in writing?
I don't know if I did it in writing or we talked over the phone about it.
Somebody files a lawsuit, and just from practice, I assume that they're going to pursue it. And so what you're saying is, no, we filed it as a placeholder. If that was conveyed to them that we're just filing this as a placeholder, that might have made a difference. But how did you convey that to them?
Well, we conversed about it. I made it clear that we regarded this as a housekeeping matter only, with maybe an occasional status report every 3 or 4 months, which is exactly what is done now on the dismissal calendar with item number 3,
and where in the
arbitrations.
Civil procedure does this dismissal calendar occur? Because in Yavapai County, we don't have such a thing. So where is that authorized, other than just our Maricopa County local practice?
I think that's it, Your Honor. It's the county court. The orders are generated. They're pink. They come out from the court administrator's office, and they say you're on the dismissal calendar, and here are the 5 circumstances in which you can extend your life on the dismissal calendar. And I only know that that's accidental research. I have another case that's on that calendar.
Okay. I just wanted to know. I've not heard of that before.
Well, I think it's fairly new in the last year or so, I would say.
Okay.
Thank you for your time. I appreciate your questions.
Any questions? Thank you, Mr. Murray. We thank you both for your arguments. This matter will be taken under advisement, and we will issue a written opinion or memorandum decision in due course. We are at recess.